Unconstitutional operation of the family courts. 1. The family courts are run unconstitutionally and illegally without proper due process and without respecting the civil and constitutional rights of citizens every day. Under the Constitution and U.S. Supreme Court case law, family court judges have no legal authority to assign custody of a child or terminate any parental rights without clear and convincing evidence, a high standard, that a parent is harmful to a child. A showing that a parent is unfit is required to terminate any parental rights. In other words, the emperor is wearing no clothes, and no one is calling them on it. Even if unfitness is proven in the case of fundamental constitutional rights, judges are required to take the minimum possible steps to protect the child without infringing on these rights. Clearly, this is not done with instant and boilerplate visitation that essentially kidnap children from their fathers for profit. 2. The liberty interest of parents in the care, custody, and control of their children is perhaps the oldest of the fundamental liberty interests recognized by the U.S. Supreme Court, Troxel v. Granville 527 U.S. 1069, 1999. Moreover, the companionship, care, custody, and management of a parent over his or her child is an interest far more precious than any property right. May v. Anderson 345 U.S. 528, 533, 1952. As such, the parent-child relationship is an important interest that undeniably warrants deference and, absent a powerful countervailing interest, protection. Lassiter v. Department of Social Services, 452 U.S. 1827, 1981. 3. The divorce court is run for the ease and egos of judges and to maximize the money lawyers make by separating the parties and causing as much fighting as possible. The best interests of the children and families is a distant third priority. Family court judges consider their time far more important than justice. In fact, lunch is often more important than justice to them, and they have been known to walk out of hearings without warning when the stomach calls. They fall asleep on the bench and have even been caught masturbating during a trial. Do you know of any other industry where 20, 30, or even 50 people at $250 per hour stand around waiting for their turn while smiling and doing nothing for their clients? This happens every morning in family courts. This would be considered fraud in most industries, especially since many are billing 2 and 3 clients for the same time while waiting. This is fraud, plain and simple. 4. Family court judges do not care what the law says and will do whatever they want because they have legislated themselves near total immunity. You only have the rights you know and demand and show you are willing to fight for by calling that judge to task, with hard evidence, case law citations, judicial complaints, a near waste of time since the foxes are watching the henhouse, and suits in federal court. 5. The U.S. Constitution, U.S. Supreme Court, and state constitutions trump any lower laws. This is the law of supremacy. Ignoring these higher laws is technically treason against the U.S. government by a judge and a violation of their oath of office. Under the Constitution, no state is allowed to make any law that takes away fundamental constitutional rights of we the people, and there is enough Supreme Court case law to choke a horse on parental rights.